If federal lands are routinely transferred to a new ranch owner by a private deed of sale, a private property right in the federal land is obviously involved. This concept was reinforced by the Stock Raising Homestead Act of 1916, confirming ranchers own the surface water and grazing rights on their allotments, and why they can buy or sell them. So, just how far do ranchers' ownership rights extend on our BLM-controlled Nevada rangelands?
So Congress did make clear in the Taylor Grazing Act that the grazing permits don't convey a private property right, but this question often gets tied up in the semantics of right versus privilege, and what these permit holders do have is the preference. They're first in line for any grazing that does occur on that land.
It's similar to owning a long-term lease, like on a townhouse in a big city, in that you own that lease, but there is steps that the leaseholder can take to vacate it. And that's my understanding of how it can work with public lands grazing as well.
What happens if the BLM or Forest Service decides to cancel a rancher's grazing permit on his public land allotment? Do they have the right to do that? What happens to the rancher's legal water rights and rights to grazing in that case?
The regulations do provide definitions for a variety of prohibited acts. However, permit revocation is never the first step for any of those things, and it's always the desire to solve the problem without it escalating, which could eventually end up in having repercussions.
If a grazing allotment should be taken away from a permittee for whatever reason, there's a tremendous financial loss, in my opinion, to both parties, because the BLM or the forest, whoever is losing a steward of the land. The steward of the land is losing the investment that he's made in that land. Everybody's losing.
Here's the dilemma. The rancher owns the grazing rights and water rights on the allotment under which the grazing permit is issued. If the BLM revokes the permit, are they not then denying the rancher's right to graze the allotment? Are they denying the rancher's right to compensation for property taken under our Constitution's 14th Amendment?
The regulations do provide instruction. In those instances, there's an appraisal process, and depending on things like who paid for the materials and who provided the labor to install the improvement, and then there is a monetary compensation for those losses.
We maintain a lot of water developments and miles and miles and miles of fences, all as part of usually what we refer to as an allotment management plan. And you understand this as a permittee. When you sign that permit, these are your responsibilities. And we understand that. When we sign it, we take on that responsibility. The thing I think that's really important to stress is that there's a tremendous cost that goes with that. Because if anybody knows what vehicles and tires and fuel and all that costs, you add your labor costs and your fence material costs and salt and all this stuff into it, and that becomes a pretty big monthly charge.